today. The theme is AI governance and board liability, integrating technological innovation with corporate accountability. But before we go into this session, we have amazing people in our midst. And I just want to use this opportunity to recognize the presence of the chairperson of the MBA SBL in the person of Ozofu Latunde Media. We are very, very, very welcome. We also recognize also our council representative here in the person of Dr. Fatima Kere Ahmed. And we also welcome our distinguished guests, our speakers, and each and every one of you joining us here. We had about 1,200 registered participants, and we are very happy because we know it will be a full house. And so I'm very happy to also introduce my executive team also here present. Thank you very much. I would want to request, do we have our amazing SBL chair, Ms. Ogbemedia, Mrs. Ogbemedia, speak? Just give us a few thoughts, a few comments if you can before I yield the mic also to Dr. Kiri Ahmed to just speak for me a few minutes and before we start the session. Thank you once again for joining.
Okay, good afternoon, everyone. And thank you, Rosamond, for your kind introduction. Afternoon, everyone. And welcome to this webinar on the topic AI governance and board liability, integrating technological innovation and corporate accountability. On behalf of the Nigerian Bar Association section on business law, I'm pleased to convene this timely conversation through our corporate governance committee. I think it brings together some of the conversations we've been having at the SBL. Last year, you would recall our annual conference focused on the use of technology in law. And our corporate governance committee has been working hard, leveraging some of the relationships we have, particularly with the stock exchange and the Chartered Institute of Directors, on improving corporate governance in this market. So I think this webinar is quite timely, and it brings together the work that this committee has been doing. So well done, Rosamond. Today's discussion goes to the heart of modern corporate governance. Boards are increasingly required to understand not only the commercial benefits of AI, but also its legal, ethical, and regulatory implications. So questions around duty of care, risk management, transparency, and liability are being reframed through the lens of technology. In this session, we have brought together expertise to help directors, advisors, and practitioners think clearly about how to integrate AI responsibly while meeting governance obligations and maintaining trust. I would like to thank our speakers, some of whom have answered us not for the first time. We've had some of you join us on other platforms of the SBL, so we're grateful that you accepted to speak and train us once again to share your expertise and your knowledge. We're really appreciative of your time. And also thanking the participants. Without you, we'll just be, talking to ourselves. So thank you for joining us, for taking an hour out of your afternoon. And I know that we are on a tight timeline, so I will round it off there. Rosamond, just so you know, the MBA SBL Executive Committee members will do the closing remarks. So I think you can go right to your session.
All right, thank you very much. So with that, I would love to yield the floor to our amazing moderator in the person of Adamu Abubakar Ishaq. So thank you very much. And the floor is yours. Please take it away. Thank you.
Thank you so much, Rosamond. Thank you. And thank you to all our distinguished speakers who actually joined very, very early for the past 30 minutes, been with us, and we've been discussing with them even before we start. Thank you so much for giving your time, to speak to us. As Madam Chair just said, it's a timely conversation. It's a conversation that needs to be discussed, and that is the reason why at the committee level, we felt it's very important to have this conversation and to invite these distinguished speakers. Thank you so much once again to the attendees for joining. briefly, this is how the webinar is going to be. We're going to have 15 minutes presentation by all the speakers. From there, I, as the moderator, would ask a couple of questions and then yield the mic to my ESCO members. If they have anything to add, we add, and then if we still have time, we take questions from the attendees. And please, if you have any question, you can use the question and answer box, put in your question in there. I'm sure our speakers are going to be ready to answer it. Today's session promised to be both timely and thought-provoking, as Madam Chair has said. We will be exploring the theme AI governance and body innovation with corporate responsibilities. It is a subject that sits right at the intersection of law, technology, and corporate responsibility. As it has been rightly observed, this is a critical conversation as artificial intelligence becomes increasingly embedded in corporate decision-making. Board accountability can no longer remain theoretical. It must evolve in step with the technology itself. The questions are no longer about whether AI influences governance, but also how board responsibly oversee its use while managing legal and regulatory risk. We are privileged to have these distinguished speakers. Each of them, I'm sure, bring a wealth of experience as board members and decision makers. And they do have deep insight into governance and corporate responsibility. This webinar is going to last for an hour, and our speakers will help us unpack the complexities of AI governance and board responsibilities. So thank you so much. And we have 3 distinguished speakers. The first speaker is Mrs. Bola Tinubu. We also have Nkemdi Waji Bego. We also have Mr. Ethan Ogbemi. So our first speaker is I'm going to introduce our first speaker. Is going to have the first 15 minutes to talk to us about the topic of this webinar. Permit me, Madam Chair, and to introduce our first speaker, Bola Tinubu. Bola Tinubu is a country managing partner of DLA Piper Africa Nigeria, where she leads the firm's corporate practice and drives its corporate and sustainability governance agenda. With over 3 decades of legal practice, she advised on company law, directors' duties, and governance framework, working closely with boards, regulators, and business leaders to strengthen accountability and advance sustainability performance. Bola is a tri-sector chairperson with leadership experience spanning in private, public, and development sectors. She has chaired organizations across private, public, and non-profit sectors, including the Boardroom Africa and the Lagos State Office of the Public Defender. She also serves on the board of Connect Creation Inc., an investment platform of Afrexim Bank, supporting African creative industry, and she is an independent member of governance committee of Oxfam International. A strong advocate for inclusive leadership and gender diversity in boardroom, Bola regularly speaks at Global Forum on governance trends and leadership development and ESG integration. Bola was named by BBC as one of the BBC 100 most inspiring and influential women in the world in 2018. I received a recognition of her work as a child advocate and in strengthening Nigerian child protection system. Mrs. Bola is going to give us the first presentation in the next 10 minutes. Mrs. Bola, the floor is yours. Thank you.
Thank you very much and good afternoon. Thank you to the NBA SBL for extending this invitation to me. So I'm going to share my presentation right away. And it just failed, so I'm just going to try it once again. Right, and it is a pleasure to be here to discuss this very important topic, AI governance and board liability. Now, let me start with 3 numbers that should concern us all. So according to McKinsey in 2025, 2/3 of directors globally had limited or no AI knowledge. Now, at the same time, you have 88% of organizations already deploying AI in at least one function. Now, that is a huge governance gap. At the same time, only 1 in 4 organizations having a board-approved AI governance policy. And what we're going to learn today is that in AI liability cases, plaintiffs don't need to prove that the AI system failed. They only need to prove that the board didn't govern it. And it's within this context that these figures have significance. Now, let us bring this directly to Nigeria. The Nigerian Data Protection Act, it imposes fines of up to 10 million or 2% of annual turnover, whichever is higher, for serious data protection breaches. Now, AI systems are almost without exception data processors, which means that every AI deployment in any organization is a potential NDPA exposure. Now, Nigeria has currently 0 dedicated AI statutes. Now, this doesn't mean that directors are off the hook. It actually means the opposite. The existing duties under the Companies and Allied Matters Act, they apply fully to every single AI system that companies deploy today. And then we can also see that AI is being deployed across sectors in credit decisions, in compliance, in employment issues, other areas across Nigeria. And currently we have reportedly over 80% of Nigerian fintechs using AI for fraud detection. So AI governance is not aspirational. It is an immediate operational reality for us, and boards can no longer look away. Now, looking at our regulatory context, Nigeria's AI governance framework rests on 4 pillars. At the constitutional level, we have the 1999 Constitution, which protects our fundamental human rights to privacy, dignity, fair treatment. And so any AI system that profiles individuals or discriminates without lawful justification potentially touches upon these rights. And at the statutory level, CAMA is our primary governance statute, and it imposes fiduciary duties, the duty of care, the duty of skill, and diligence on directors. The Nigerian Data Protection Act imposes binding obligations on data controllers. And most AI systems, again, are data controllers. And of course, we have the Cyber Crimes Act, which reinforces the system security obligations. Now, at the regulatory level, the NITDA has issued both a national AI policy in 2022 and a national AI strategy in 2024. And SEC has also issued AI-specific rules. Other regulators like the CBN, NCC, and NICOM, they're all developing their own sector-specific frameworks. And internationally, of course, the OECD principles, the EU AI Act, and the US NIST framework, which we'll talk about later, these all set global benchmarks that Nigerian boards need to understand, particularly those with international operations. And the key point here is that the absence of a dedicated AI law doesn't mean that boards are free from obligation. And I would argue that the current absence of a specific AI law actually heightens that responsibility. So to ensure that directors now need to exercise proactive and documented oversight. Now, looking closely at directors' duties, directors in Nigeria owe 2 primary duties under CAMA. That relate directly to AI governance. So the fiduciary duty under Section 305, this requires directors to act in good faith and in the best interest of the company. And within the AI context, this means ensuring that your AI systems promote corporate value and they do not undermine them. It means that you're preventing AI washing, and this is where companies are overstating their AI capabilities in their disclosure. It also means ensuring that the board cannot simply hand AI oversight to, let's say, the chief technology officer. Now, the duty of care, skill, and diligence under Section 308, this requires the exercise of the care of a reasonably prudent director. And today in 2026, a reasonably prudent director asks questions about AI. They understand what AI systems the company uses. They understand what risks they carry, what oversight mechanisms are in place. And a director who is willfully ignorant of these AI risks is one that has clearly fallen below the legal standard. And what's important here to note is that AI is not creating new duties, but is intensifying the consequences of the existing ones. The duties are the same, it's just that the stakes are higher. Now let's map the 6 key areas where AI governance failures translate to director liability. So the obvious one is data privacy and cybersecurity. This is the most immediate risk in Nigeria right now. The NDPA imposes these binding obligations on data controllers. And as we said, AI systems process personal data. So this is directly relevant to what we're talking about. If an AI system makes a flawed credit decision or generates a misleading analysis that a board relies on, the company and its directors may face financial or product liability claims. If, as we know, AI systems are trained on historical data, and they can perpetuate discrimination, whether it's in credit, whether it's in employment or insurance decisions. And these are both regulatory as well as reputational risks. Public statements or investor disclosures about AI capabilities that are inaccurate can also constitute a misleading statement or fraud. And as regulators continue to develop their AI guidance, non-compliance will continue to attract enforcement. Now, a common misconception that I encounter is this. Directors tell me, oh, we have a chief technology officer, we have a tech team, we have an AI team, they manage AI, not us. And this completely misunderstands the governance framework entirely. The board is responsible for strategy, for risk appetite. It approves policies, it ensures that the right structures are in place, while management is responsible for execution, the day-to-day deployment, operations, reporting. And what we need to remember here is that the operational responsibility can be delegated to management, but the ultimate accountability cannot and remains with the board. So if your CTO deploys an AI system that causes a major data breach and the board has no governance framework in place, no oversight structure, the board may be liable, not just the CTO. And the legal standard under CAMA is clear, and this is supported by case law. Boards must ensure that functional information and reporting systems exist. And passive boards that don't have these systems in place are the ones that are legally exposed. And I want to pause here and ask, I'm sure many of the directors that are on the call, to run a mental checklist against these 9 warning signs. So does your board have a formal AI governance framework or policy, one that defines oversight, risk appetite, accountability, not just a general technology policy? Does management report on AI risks to the board on a regular, structured basis? Does the organization know where its data come from? So as we know, garbage in, garbage out. And if any of these apply to your board, or you have a governance gap. And as we can see from the case law, it's these governance gaps that create director liability. And this checklist is not to frighten you, it's designed to help you to identify where action is needed and before a regulator or a court identifies it for you. And now it's important to talk about the protection that directors enjoy under the business judgment rule, as well as its limits. Now, this is a common law doctrine that provides that a director who acts in good faith on an informed basis and in what he or she reasonably believes to be in the company's best interests will generally be protected from personal liability, even if that decision ultimately causes loss. However, this business judgment rule only protects decisions. It does not protect governance failures. So if we look at the left column, this is what protection looks like. AI on the board agenda, management reports reviewed, policies approved, you have a committee structure in place. And looking at the right column, this is what exposure looks like. AI is never on your agenda, no governance policy, no committee oversight. And the dividing line between these two columns is documentation. Board minutes are your legal evidence. If your minutes show that you asked the right questions and you directed management appropriately, you are protected even if something goes wrong. But if your minutes are silent on AI, then you have no defense. So what do boards actually need to do? Let's walk through a 6-step practical framework. So first, you adopt a formal AI governance policy. Not a general IT policy, but a document that specifically addresses AI. So it's risks, board roles, management responsibility. You decide which committee will own that AI oversight. And then you conduct a comprehensive audit of what AI systems are currently in use and the others you may be unaware of. And you assess each system's risk profile. You also require management to report to the board on AI matters on a regular cycle and not just when something goes wrong. You also ensure that there's that human oversight mechanism that is built in. And critically, importantly, you must invest in director AI literacy. I cannot repeat this enough. This is critical. Boards that understand AI are just better able to challenge management assumptions and defend their governance decisions. And of course, you ensure that you build regular review cycles into your board calendar. And we need to build the practical architecture behind that framework. So you think of it in 3 tiers. So at the board level, this is the fiduciary layer. The full board approves the AI governance policy annually. It reviews the AI risk at a minimum biannually. It must receive a comprehensive governance report and ensure AI oversight is disclosed in its annual report. At the committee level, and this is a structured oversight layer, your risk committee receives quarterly AI reports. Your audit committee includes AI in its audit plan. And your nomination committee assesses board AI literacy. And for organizations with significant AI deployment, I would suggest that you consider a dedicated technology or AI committee. At the management level, of course, you have a cross-functional AI governance committee, designated chief AI officer, and a maintained AI risk register. And again, the connective tissue running through all these levels is the documentation and what protects you. Let's quickly look at what boards are doing in other jurisdictions, because this gives us the international standard of care against which Nigerian directors will increasingly be assessed. So in South Africa, King 4 governance code has made AI a matter of ethical leadership. So South African boards are expected to interrogate not just the efficiency of AI systems, but their fairness, their explainability, and shareholder impact. The EU AI Act is the world's first binding AI law. It classifies AI systems by risk, and it imposes board-level governance obligations for high-risk systems. Now, its extraterritorial reach means that any Nigerian company that affects individuals in the EU will be subject to these requirements. There's been a new addition to the UK Corporate Governance Code in 2026, and it now requires boards to review the effectiveness of material controls and explicitly includes AI-related risks. And of course, in the US, we're seeing voluntary standards becoming the legal standard. And I would like to just take a quick moment on case law. One of the important Nigerian cases is Cadbury Nigeria PLC and SEC, a well-known case, where directors were sanctioned for false financial reporting arising from failures in internal controls and supervisory mechanisms. Now, this decision confirms that directors cannot shield themselves from liability by asserting reliance on management or auditors where systemic failures occur. The Barings case is a leading case in the UK, where Nick Leeson's unauthorized trading led to the collapse of England's oldest investment bank, and importantly for our purposes, the disqualification of the directors. And it was held here that the directors have a positive duty to monitor and supervise operations. I've included MTN here. This was a regulatory infraction where NCC imposed a fine of 330 billion for the violation of its regulations. Now, while this matter didn't touch on the issue of directors' liability, it's still important, not just because it shows that our regulators do have teeth and they will bite, but the breach of not deactivating those unregistered SIMs in line with the regulations may have reflected an internal accountability and governance framework that allowed established regulations to be overlooked and internal controls that did not ensure compliance. And within the context of AI governance and director liability, our statutory duties require directors to understand the implications of AI systems used by the company, including their risks, their limitations, and certainly the potential impact. And a failure to exercise that due care may constitute a breach of duty. And finally, as board members don't need to be data scientists, they don't need to be machine learners, but what they need to do is to ask the right questions, and here a few questions across 4 categories. And so directors must ask these questions. What is our AI maturity? What's our strategic risk exposure? Do we have an AI governance policy? Who owns it? Are AI systems assessed for risk before deployment and not after? How do we measure whether AI is actually delivering value? And if you can't answer these questions today, then the work of AI governance is not yet done. And I'd like to close with these 3 principles I'd like us to carry into our next board meetings or meetings with our clients. AI governance is a board responsibility. Existing duties apply, and now with intensified consequences. And thirdly, early deliberate action protects, where passivity exposes you to liability. Thank you very much for your time.
Thank you so much, Bola. Thank you, thank you, thank you. I'm sure this 15 minutes, as Rosman said, it's really, really unfair, you know. It was really insightful. Thank you so much for that wonderful presentation, resourceful, and I've learned a lot from it. Thank you so much, Bola. And we're going straight to the next speaker, Mr. Eton Ogbemi. Mr. Eton Ogbemi is a co-founder of Integrate AI Human Technologies Limited and founder of Etrox USA LLC. With over 20 years of international executive experience, he advises organizations across the legal, public, and financial and energy sectors on AI strategy, governance, risk, and responsible AI implementation and transformation. He works with boards and leadership teams to translate AI ambition into accountable, practical action through Integrate AI umbrella company, incorporating IHTL trusts and IHTL Active 8 methodologies. Ladies and gentlemen, permit me to welcome our next speaker, Mr. Ogbemi. Mr. Ogbemi, the floor is yours. Thank you.
Good afternoon. Permit me to call you my learned friends, even though I'm not a lawyer. Can you confirm that you can see my screen, please, Adamu?
Yes, we can.
Great. So my name is Etan Ogwemi, and thank you for inviting me to participate in this webinar on how AI impacts governance and board liability. I'm a founder and the Chief Executive Officer of Integrate AI Human Technologies. We're here today to discuss a critical topic, AI governance and board liability. AI is no longer a future technology. It's embedded in how organizations operate. The real question is not if boards should govern AI, but if they are doing it well enough to protect the organizations and themselves. This session will tackle that directly, incorporating Nigeria's latest regulatory developments, including the newish GATE 2025 directives. Let's explore why this is now a board-level imperative. Boards have always been responsible for material risks. AI is now undeniably a material risk. The duty of care under CAMA 2020 requires directors to be informed. This isn't just about financial or operational risks. It's about technology risks that could lead to regulatory sanctions, litigation, or reputational damage, as Bola had discussed earlier. Shadow AI is a prime example. Employees are already using generative AI tools like Claude, Gemini, Manus, ChatGPT, and so on, with company data, often without any policy or oversight. This creates massive unquantified enterprise risk. So how has the regulatory landscape in Nigeria evolved to address these concerns? The regulatory environment in Nigeria has fundamentally shifted. The General Application and Implementation Directive 2025, which came out of not out of NDPR, but out of the commission that was established by the Data Protection Act, is not merely a guideline. It's actually a directive issued under the authority of the 99 Constitution and the NDP Act. It completely supersedes the NDPR 2019. Every organization that processes personal data, including through AI systems, is now subject to these binding obligations. Boards cannot simply delegate this away to IT or compliance teams, as was pointed out by Bola earlier. It demands direct board-level oversight. So let's dive deeper into what GATE 2025 means for organizations. The GATE 2025 is the most significant development in Nigerian data protection law since the NDP Act itself. It provides the detailed implementation rules organizations must follow. For boards, this is critical. GATE creates specific time-bound obligations. Missing the compliance audit returns, the CAR filing deadline, failing to designate a data protection officer, or deploying AI without a data protection impact assessment are all compliance failures. The NDPC can investigate and sanction these failures. As we heard earlier, 2% of revenue is the fine that can be imposed. For a company that has revenues of 10 billion naira, say, that fine, if it's imposed for any violations or any compliance failures, can result in wiping out the entire profit. That's about 200 million naira. That can wipe out the profits for that company for the year. So this affects shareholder value. This can affect shareholder value directly. The NDPC can investigate and sanction these failures. Boards must actively ask management, are we compliant with GATE 2025? This brings us to the core of directors' fiduciary duties in this new era. The courts and regulators don't distinguish between technology decisions and governance decisions. If an AI system causes harm, whether through a data breach, discriminatory output, or financial loss, the board will be asked about its oversights. Directors who can't answer that question are exposed. The GATE 2025 makes this even more acute. It creates specific obligations that management must fulfill, and the board must verify their fulfillment. But what are the broader legal risks if AI remains ungoverned? As we discussed, directors cannot plead technical ignorance. But what exactly are the legal risks when AI is left ungoverned? Each of these four risk categories has real-world precedents. IP exposure from generative AI is already the subject of litigation globally. Data protection failures under NDPA and GATE 2025 carry significant penalties, as I mentioned before. Algorithmic bias is increasingly scrutinized by regulators, and vendor contracts almost never adequately address AI-specific liabilities. Boards must ensure each of these risk areas is addressed in their governance framework. This is about protecting the company from multiplying legal exposure. Now, let's connect these risks to the specifics of GATE 2025. The tiered classification system is one of the most important practical features of GATE 2025. Organizations that process large volumes of personal data, operate in financial services, healthcare, or e-commerce, or use AI for automated decision-making are very likely to be classified as UHL, that's ultra high level, or EHL, extra high level. This means mandatory annual CAR filing, a designated DPO or DPCO, and mandatory DPIAs before any new AI deployment. Boards must ensure management has determined the organization's classification and is meeting the corresponding obligations. Your classification directly dictates your obligations. Building on that classifications, these are not aspirational standards. They are binding obligations with enforcement consequences. The Nigeria Data Protection Commission has the power to restrict an organization's operations if it fails to comply. Boards must receive regular reports from management, as we heard previously, confirming compliance with each of these obligations. The annual compliance audit return CAR filing deadline of 31st March is a hard deadline. You must file by that date. The board should have this on its governance calendar. These are specific time-bound duties that require direct board oversight. So how does GATE 2025 specifically address AI deployment? Article 43 of the GATE 2025 is the most directly relevant provision for organizations deploying AI. It creates a clear governance obligation. You cannot simply deploy an AI system and hope for the best. You must assess it, you must test it, and you must document it and continuously monitor it. The concept of disparate outcomes is particularly important. If your AI system produces results that disproportionately harm certain groups, that is a regulatory and legal problem, even if the system was not designed to discriminate. Boards must ensure their AI governance frameworks address all of these requirements. This article makes AI governance a binding obligation, not an option. And a key part of that governance is understanding lawful basis. The lawful basis question is one of the most important governance questions for any AI deployment. Many organizations assume legitimate interest covers everything. GATE 2025 makes clear that it does not. Automated decision-making with legal effects requires explicit consent. Profiling sensitive personal data requires explicit consent. Boards must ensure that for every AI use case, the lawful basis has been identified, documented, and verified by the data protection officer. This is not a one-time exercise. It must be reviewed as AI systems evolve. This is about ensuring every AI action has a legal foundation. And a critical tool for this is the DPIA. The Data Privacy Impact Assessment, or DPIA, is your board's most critical assurance tool for AI governance. We just discussed the lawful basis for processing data. Now we're looking into how to assess the risks of that processing. Under GATE 2025, Article 28, a DPIA is a mandatory, that assessment is mandatory before deploying any AI system or high-risk data processing. This isn't optional, it's a hard requirement. The DPIA must assess not just technical risk, but also the potential for disparate outcomes. This means looking at whether your AI system could disproportionately harm or disadvantage certain groups. The NDPC has significant power here. They can restrict your operations if you fail to conduct a DPIA. So boards must ensure this process is embedded in every AI project's governance from the start. This leads us directly to the critical issue of managing AI data breaches. Managing AI data breaches under GATE 2025 demands board-level incident readiness. The 72-hour notification window is extremely tight, and it starts from the moment your organization becomes aware of a breach, not when it's fully confirmed. This is a very, very short window. Boards must ensure a clear, tested incident response protocol is in place. This protocol needs to include immediate escalation to the DPO, legal counsel, and board-level notification. Article 32 introduces the concept of abatement, meaning passive inaction, as Bola talked about earlier. Meaning passive action in the face of a known breach is a regulatory violation. This is a significant legal exposure for boards. Next, we'll examine how to structure AI vendor contracts to protect the organization from these risks. Following our discussion on breach management, we must now consider how to structure AI vendor contracts under GATE 2025. Standard software as a service agreements are simply insufficient for AI. GATE 2025 Article 34 mandates specific provisions in all data processing agreements, or DPAs. Legal advisors must negotiate these bespoke protections. This includes explicitly prohibiting vendors from using your data to train their foundational models without separate consent. You also need transparency and audit rights to understand how the AI makes decisions. It can be a black hole sometimes, and to check for bias. Robust IP indemnification is crucial, protecting against claims that AI outputs infringe on existing intellectual property. Finally, you must define who bears liability for AI hallucinations. AI lies. When the AI produces factually incorrect information, these are all critical elements for board oversight. Now, let's look at a practical framework for implementing this governance. We've discussed the regulatory landscape and the risks. Now, let's turn to a practical solution. The IHTL FLAIR system. This framework turns AI governance from an obligation into a strategic advantage. IHTL FLAIR is designed to align AI adoption directly with your corporate objectives. It has two core components, IHTL Trust and IHTL Activate. IHTL Trust is our continuous governance engine. It ensures ethical alignment, assigns clear risk accountability, and creates audit-ready evidence for the regulators. You will recall earlier in the earlier presentation how the documentation of what happens in your minutes is what will protect and what does protect doctors from regulators. IHTL Activate is our structured implementation and operational methodology for safe AI deployment. It covers assessment, sandbox testing, and rigorous validation before full rollout. These are not abstract concepts. They are practical tools that directly address the regulatory obligations we've been discussing. Let's see how FLAIR aligns with GATE 2025 obligations. Building on the FLAIR system, this slide shows how it directly addresses every GATE 2025 mandate. The IHTL FLAIR framework provides a structured path to compliance for boards. Each board must develop a framework. So while IHTL has one, this is just an example of the type of framework that needs to be implemented by organizations. For example, IHTL Trust maintains continuous audit-ready documentation, making annual CAR filings straightforward. IHTL Activate embeds the mandatory DPIA as a standard step in the AI deployment methodology. It also used controlled pilot environments for sandbox testing as required by Article 43. IHTL Trust then provides ongoing monitoring for disparate outcomes. The FLAIR governance structure integrates the DPO and ensures DPA compliance. It also includes incident response protocols for the 72-hour breach notification. Organizations that implement IHTL FLAIR are not just meeting regulatory obligations. They are building a governance structure that creates competitive advantage. Legal advisors are now indispensable partners in navigating the GATE 2025 landscape. This directive creates specific legal obligations that demand expert interpretation and implementation. First, they must review all vendor contracts to ensure GATE 2025 compliance. This includes data usage rights, technical measures, and indemnity provisions. Second, legal counsel provides crucial regulatory compliance advisory. They guide boards through CAR filing, DPO designation, and DPIA requirements. Third, lawyers help design and implement robust risk mitigation strategies. This includes frameworks like IHCL FLAIR to address algorithmic bias and automated decision-making risks. Finally, legal advisors play a vital role in board education. They ensure directors understand their fiduciary duties under CAMA 2020 and GATE 2025. As was mentioned earlier, continuous training must also occur at the board level. This empowers boards to ask the right questions of management. These four roles are critical for ensuring comprehensive AI governance. This audience, as members of the NBA SBL, is uniquely positioned to provide this essential guidance. Thank you for your time and attention today. We've covered a lot of ground, from the imperative of AI governance to the specifics of GATE 2025 and how frameworks like IHCL FLAIR provide practical solutions. I look forward to your questions you can have, and you can find us if you want more information about our methodology and our framework. Thank you very much.
Thank you so much, Mr. Ogbemi. Thank you. We're really sorry for not giving you enough time to cross here. Thank you so much for that insightful presentation. I'm sure the audience have questions. And to the audience, you can start writing your question at the question and answer box, please. And I'm sure the speakers are observing the Q&A box for your questions. Thank you so much, Mr. Rubemi. Quickly, our next speaker is Nkemdili Uwaji-Bego. She is a technology executive and a serial entrepreneur and a non-executive director with 20 years of experience driving digital transformation, AI adoption, and innovation across Africa. She is the CEO of FutureSoft, and she has led digital transformation and innovation projects for 200 plus clients across 20 industries and trained over 1,500 executive and board members on technology governance and strategy. Thank you so much, Uwaji, for joining us, and the floor is yours. Thank you so much.
Thank you very much. All right. So I'm very excited to be here. Good afternoon, everyone. Like Adamu has said, my name is Nkemdili Uwaji-Bego, and I think the other two speakers have done a really good job, sort of setting the scene, and I think they will make it a little bit easier for me. So I want to start by just, kind of talking about the state of AI and what we're seeing in 2026, right? And I think this is really important because a lot of the time when I talk to board members and executives that are not technical about AI, it's, sort of, oh, but it's just like software. It's just, we're just automating things, or the AI will just help us do certain things. But AI is actually reshaping the world, right? We've seen different companies announce layoffs, including Jack Dorsey's Block that laid off 4,000 people. Oracle just laid off 30,000 people. JP Morgan has replaced human advisory firms with an AI shareholder voting system across its 7 trillion asset business. McKinsey has 20,000 AI agents as employees out of 60,000 in total. And these are just a few examples that really show you how AI is actually reshaping the world. But it's also, the security side is there. Google revealed that attackers used 100,000 different prompts in attempting to clone their entire LLM. AWS suffered 13 hours of outage after engineers let its AI agent make autonomous changes. And like both the previous speakers said, Nigeria is, on the way at the moment to set an AI law. But currently there is no, sort of focused AI regulation, which makes it very difficult for board members and executives. But I think, as you can see from this, there are multiple, sort of nuances to, AI. So it's not just around fiduciary duty, it's really about business strategy as well. And I think that's, sort of maybe a bit of different angle that I can bring in today and just, sort of share what I've seen as a practitioner. So first of all, this is the landscape of AI. And I'm sure you're wondering, why are these logos so small that we can't see them? This is just really to show you how many different AI companies are out there and how many AI providers are out there across infrastructure, analytics, machine learning, applications and agents, enterprise, consulting, data, sources, APIs. It's a whole lot, right? And this is just to really allow you to understand that AI is not just your Claude, your Gemini, your ChatGPT, right? AI is so much more. And a lot of existing software companies are actually transitioning into becoming fully AI enabled, which means that even your existing technology stack, even if you haven't brought in any new AI, your existing technology stack is very likely to already have AI integrated in it. Now, when we talk about, the world is changing, AI also is changing the way that companies are valued. So the current AI market is valued at $233.46 billion, and is projected to reach $1.7 trillion by 2032. It's growing at a 29.2% CAGR, and it's basically just, changing everything. So it's really not about, should you be doing AI? Should you know about it? It's really, you have to know about it. So leaders should embrace AI transformation because it, first of all, helps you with your decision making, right? Which also means that bringing it into the boardroom, not just from a strategy perspective, not just from a risk perspective, but from a data and insights perspective is also really, really critical. It helps with operational efficiency. The organizations that are laying off 4,000, 30,000, 12,000 people are replacing these people with AI, right? You can decide whether that is, something that you want to do within your organization or not, but your competitors probably are on that track. Improved customer experience can also be achieved through AI. You can build your competitive advantage, and most of all, you can future-proof your business. So if you don't think that you need to know about this because of fiduciary duties or risk exposure, just learn about it, because if you don't, your business will be dead in the next 5 years. And that's not really an exaggeration. It's just simply what it is in this day and age. Now, there's been this sort of controversy last year, which basically said that 95% of AI pilots fail. And it was this, it really went viral. There was this MIT study that basically said that, 95% of AI pilots actually fail. And, I just needed to dig a little bit deeper into that. And I realized that there's a huge leadership and board level gap, right? So fewer than 20% of boards had received structured AI literacy training. And I think Bola presented similar numbers. There's also a really big misalignment at the top, creating fragmented decision-making and reactive governance. And then obviously the risk frameworks haven't really been updated for data privacy, cybersecurity, and ethical use of AI. Like Bola mentioned, your risk exposure just multiplies, right? And then there are also a lot of cultural gaps. So a lot of limited training within the organizations, shadow AI being used. Shadow AI is basically when people in your organization are using AI without you being able to monitor or regulate it, right? This can happen if you don't have an AI use policy. It can happen when you are not monitoring it. And this can actually expose you to a lot of risks, including data breaches. And there's some very interesting case studies. Samsung lost $200 million market cap because one of their developers decided to debug the code with a free version of OpenAI's ChatGPT. And their entire code base was leaked, right? Now, this is something that, the developer was trying to be proactive. He was trying to be smart. He was trying to, make his work faster. He probably had a deadline. But he just didn't have enough knowledge in terms of what he was supposed to do. But who's liable for the share price? The board, right? So you can't go and say, oh, but it was the developer. No, they'll come to you. So what we're also seeing is that when a lot of organizations launch pilots, they're not really thinking about what are the success metrics. They're not thinking about what is the return on investment. So the story isn't about AI failing. It's a story about organizational readiness and leadership maturity just not being in place. And I think that's even more dangerous than a lot of the, risks that you see, right? Just not really understanding what do we actually need as an organization to be ready for AI transformation, and what do we need in terms of leadership maturity, in terms of understanding, in terms of the knowledge that we need, both at board and executive level. So there's obviously leadership alignment being like one of the single most critical success factors for making sure that AI pilots succeed. A lot of the time, there's lack of executive sponsorship. There's not a shared understanding of what AI really is. And this goes back to just common literacy at the top. There's a weak alignment with business strategy where there are random experiments because you've left it to your CTO, your CIO, your chief data officer, and you're like, yeah, let the IT guys experiment. That doesn't really help you because it's not aligned with your business strategy. AI is a strategic lever. It will help you win in this decade. So really understanding how that will work is very important. Like, I think it was Bola that said you don't need to become a data analyst, but you need to understand the basics. So according to McKinsey and Company's Global AI Survey, organizations with an active C-suite leadership were 77% more likely to scale AI successfully. Those without rarely move beyond the pilots. And that's why these numbers of pilots failing is so high. Obviously, there's also additional risk around cybersecurity and privacy risk. Ethan had already spoken about privacy quite extensively, and also unrealistic expectations where executives often expect overnight transformation. But the truth is that AI transformation, like any other business transformation, takes time. So you need to be patient, you need to iterate. The technology is still evolving. The technology is not failure-proof. The technology sometimes goes crazy. So there's a lot of risks, but also a lot of opportunities. And then another issue is poor cross-functional collaboration. AI cuts across everything: IT, legal, risk, HR, ops. And if you don't bring everybody to the table, then that's a clear, you set yourself up for failure, basically. A lot of the time, you also have outdated systems, you have poor data, you have lack of ownership at your team level, and really just understanding all of those different things is really important. But AI transformation is 80% human and only 20% technical. So you have AI literacy gaps that you need to tweak. You need to make sure that there's change management, and you need to make sure that you have specialist talent as well, right? Does this sound like Remco? Right? So this is the work that you've kind of cut out for yourself. You need to make sure that you have your ROI. You need to make sure you have a proper strategy in place. And you need to make sure that obviously you have ethical, legal, and regulatory oversight of everything. Now, some of these have already been talked about, but the key governance challenges really is that AI is a black box, so you don't know what's inside. There's also, a lot of issues around just balancing what's our risk appetite around innovation versus risk management, and making sure that the corporate culture is aligned with what your AI strategy actually says. So there's a lot of work for boards and a lot of new considerations. So you basically have a completely new oversight mandate. So you have to evolve from just being passive monitors to proactive questioners of AI intent, accountability, and impact. You need to make sure that you have oversight over data ethics, AI use policies, third-party AI vendors, organizational AI literacy. So you can see how this kind of goes across all of your board committees, right? Your REMCO, your board risk committee, your board IT committee. So regardless of which committee you're in, you need to have an understanding and you need to understand the nuances of that. Distributed ownership. Because AI is cross-functional, everybody's involved, right? Which is why everybody on the board has to be involved as well. And then you need to make sure that you have transparent accountability structures, right? So if you look at the EU AI Act, for example, you'll see that traceability of data, transparency of models has to be fully documented. If not, you can get fined up to 7% of your global income or global annual revenue. You need to make sure that you're scenario planning, right? A lot of things can go wrong with AI. So your risk exposure, making sure that you know how to mitigate that. And as AI adoption also grows, so does governance complexity. AI policies need to be embedded into core operational processes. AI audit trails, monitoring models have to be in production. So AI really is going to be within the entire organization, which means that you need to know exactly what's happening. I'm going to skip this slide because I think we've had enough, regulatory guidance. I'll talk a little bit about this. I think Bola had a really nice slide on this as well. So as the board, you set the direction, you approve the frameworks, you have oversight of the high impact use cases. You monitor risk and ethics, and you ask the right questions while the executives implement the strategy, operationalize controls, execute with accountability, manage the performance, and lead culture and reskilling, right? So it's that interplay that gives you success, which means that you need to make sure that your executive management is also ready, right? So you can learn all the things that you want. If executive management has no clue, then you're still going to fail. In terms of risks, even though from an enterprise risk perspective, AI risk is very similar to what you're doing, but you have additional risk, like bias in your model, performance robustness, additional cybersecurity risks. You have ethical risk around fairness, discrimination, and transparency. And this can easily be amplified with AI. You have a lot of operational risks. And there've been, cases, for example, Knight Capital had an AI trading algorithm. It was trading the market and it didn't have a kill switch. Within 45 minutes, it lost $400 million, right? Because it was auto trading and there was nobody monitoring it, and they had to then pull it at some point. But that is a risk that the board obviously wasn't really aware of. They thought like, oh, we've created this great trading algorithm that can automatically trade. We're only going to win, right? They didn't think about what's the risk appetite, how much can we really realistically lose, and that company almost went bankrupt. So there's a lot of financial risk. Sometimes you have unexpected cost overruns, a lot of change management and cultural risk. There's a lot of fear around job loss, right? Which means that communication, change management, making sure that you have employees that are actually ready, supporting employees in the transition from non-AI work to AI-enabled work is very important. Then you obviously have a lot of risk around shadow AI, which is one of the risks that is a lot of the times overlooked. So understanding each of these risks and the nuances of these risks is really important for every board member. And here's some of the questions that you should ask. Who owns AI risk and ethics within the organization? How are you tracking performance and unintended outcomes? Are you building explainability, fairness, and compliance into the AI lifecycle? What training or support do management and technology teams and the organization at large need to lead responsibly with AI? Are we integrating AI governance into our broader enterprise risk management framework and compliance frameworks, or treating it in isolation? How are we evaluating third-party AI vendors and their accountability for bias, data handling, and model reliability? So sometimes the gaps are not with you, they're with your third-party vendors, which means that all your IT policies that have to do with third-party vendors, technology vendors that are using AI, or even a marketing agency using AI to generate your content, right, is an exposure point. So making sure that all the policies are updated, that's all part of what your board oversight, kind of has to look at. And then what metrics and KPIs are we using to assess whether our AI initiatives are delivering ethical and sustainable strategic value? Now, just to wrap up, AI introduces new and amplified risk categories. So you need to learn those, you need to understand those, you need to understand the regulations that you fall under. Effective AI governance requires cross-functional ownership. Like I said, it goes across all the different committees. You need to just wear a different hat each time. Shadow AI is a rising concern. And like I said, one of the most overlooked risks, global AI regulation is quickly evolving. AI governance failures can erode trust really, really fast. And ethical, responsible, and auditable AI deployment is not optional. So you really need to look at what are we trying to do? How does this fit into our enterprise strategy or our business strategy from the start, right? So you're not creating an AI strategy that stands alone. It has to be embedded into your business strategy, which means that it is your mandate as a board member. And with that, I'll leave you with a couple of books that I can recommend for leaders who are trying to understand artificial intelligence in practice, who are trying to understand what this actually means and how it's changing the world. There's also a really great podcast. It's called the AI Daily Brief. This discusses all sorts of different, sort of, I guess, parts of AI, the technical parts, but also what it means for humankind, what it means for leadership. So it's a really interesting and very short 20-minute listen that is worth investing in. So thank you very much.
Thank you so much. Thank you so much, Bego. I'm sure all the attendees too. It has been a very educative and insightful conversation. Thank you so much for your time. We're quickly going to the Q&A session, and the Q&A session is going to be coordinated by our first vice chair of the Corporate Governance Committee, Tayo Mustafa. Tayo Mustafa, are you on the line? Can you take us through? Yeah. Thank you. Hi.
Thank you, everyone. Thank you to our speakers for what has been a genuinely enriching conversation. So yeah, we'll move into the Q&A session. Our time is fast spent, so I want to direct two questions to the panel just before we open up to the floor. There have been a number of key takeaways today, but what stands out is AI governance is no longer a future concern. It's a very, very present one. And I think the point has been made and, emphasized that directors have not just a duty of care, but an obligation to be informed. And now to the question, I'll just kick off with Bola, and then we can have Ethan and Nkem answer. So the question is, I've just spoken about, the board has a duty of care, but also an obligation to be informed. But what does being informed actually mean when, technology is this complex and it plans on it's going to get even more complex? There's still a lot of, like Nkem has covered, there's a lot of risk involved here. As a non-technical director sitting on the board today, what does he or she generally need to know, and how does such a director, satisfy that duty without becoming a technologist, so to speak? Oh yeah.
Hi, Ty. It's good to see you again.
Hi.
And yes, it's a good question. Now, of course, the law wants us to be informed as directors, but informed doesn't mean that you have to understand every single line of every single law, regulation relating to AI. But it means that you need to understand enough to ask the right questions and to spot when something is wrong. So think of it like a director overseeing a finance team. You don't need to be an accountant, but you need to understand the numbers well enough to challenge them. So AI is no different. So it just means understanding really what Eto and Nkem have been able to articulate today. Just understanding what AI means to your business, the impact, your strategy going forward. And the danger is, directors saying, I don't understand AI, leave it to the tech team. You can't do that anymore. So it's just what is required is reasonable, active oversight. Just enough for you to be able to ask the right questions and hold management to account. That's what's critical.
Thank you. Thank you. Completely agreed. Nkem, can we get your perspective on that?
Yes, thank you so much. So I think also understanding the implications, right, of what happens if we don't embrace this, what happens and what can happen if it goes wrong, right? And really understanding the nuances around the risk, right? Because the risk is amplified by a million, right? Which means that this is not your normal technology. It's very, very different. And it's extremely powerful and it will change the entire business. Now, the question is, how will it change that business? Are you able to even imagine that? Are you able to understand that? And I think that's really the hardest task, right? Because as a director, you're tasked with giving direction and oversight to strategy. But if you don't understand the implications that this technology has on the world and how it's going to reshape jobs, how it's going to reshape markets, how it's going to reshape supply chains, how it's going to reshape, finance, then you can try and ask questions, but you are not going to be able to guide the organization very well, right? And I think that for me is the biggest part, really understanding that this technology is different from every single other technology that we've seen. This is different from the internet. This is different from, social media and digital. It is a technology that has the power to really change everything that we know today, right? The way that we do business, the way that we work. I have a 10-year-old, and a lot of the time, people are like, oh, you need to start preparing him for university. And I'm like, I don't know that there's going to be a university for him to go to in the next 8 years, right? Because I think that this technology is going to radically shift humankind. And I think that's really this both scary but also exciting part, and where I think directors should really invest in their knowledge around what are the shifts, what are the trends, what are the predictions, and how is this technology evolving, and how does that evolution of the technology affect us as a business?
Thank you. Thank you so much. Eaton?
Right. Hi.
Hi.
Okay, so yeah, this was really fantastic, and listening to my fellow presenters here. One of the issues which they've talked about and which is prominent is that, and we cannot emphasize it enough. The issue is not the technology. Governance is something that is the responsibility of boards. They will be at risk unless they start to know. I think Bola mentioned earlier the issue of training. So board training, and she suggested a couple of, I think it was Nkem who showed some books there. Listening to podcasts and things like that are also very important. But a structured training process as well, which can happen in a few hours, is often sufficient to create the awareness that boards need in managing and governing AI. The IOD the CIOD in Lagos has many such programs. They've been running for a few years. Actually, they had a lot of foresight, and I would urge people to get interested in this, especially board directors. Now, how the DPIA, which is the data protection audit, that particular requirement of GATE 2025, that provides the insight that boards will need to have in governing AI. So when the executives produce this document should always come to the board, and then the board can look at it. Developing a risk register. All boards are very familiar with risk, But AI risk particularly, there should be a risk register, which is actually discussed, and one of the earlier speakers have talked about a dedicated committee, either in the risk subcommittee of the risk committee or a standalone committee for large organizations who are deploying AI needs to have this risk register, which they will constantly be assessing to ensure that they are protected.
Thank you so much. Thanks, Ethan. So I have a number of questions, and I would drag this out, but time is fast spent. So I'll just go into the questions with the audience. So this is a bit technical, so I'll come back to you, Ethan. It says, what are specific examples of AI systems, and can disclaimers help protect against AI hallucinations? You're muted.
Okay, so the questions about protecting organizations from hallucinations. The hallucinations do occur. So like you see, if you open up your ChatGPT, you have a little writing along the bottom that says that check these results as they may be false or they may be fake. Virtually all the LLMs, the chatbots have this. Now, this is a question, actually, this part of the question is actually one for lawyers, because saying that, if you use this piece of equipment, it may harm you, is that sufficient to protect you if the harm does occur? So the issue of speaking to the risk that may occur, and then after that, if the harm does occur, it doesn't absolve you of liability. So to a large extent, you have to be able to watch and prevent these hallucinations, which is actually quite possible depending on the way that you do deploy your AI systems. We're building machine learning models for some of our clients. And the process of building the models themselves, especially when you're building models, you're not using the LLMs for that. You're doing things like predictive demand, which is an application which you develop in-house for an organization. When you develop those, you have more control over how that AI deploys. The issue of hallucination actually applies primarily to the chatbots who have been trained on massive amounts of data. When you do train, you create a model which you train on a company's specific data, the risk of hallucinations is a lot less. You know where the data is from. You've done through an exploratory data analysis. You've cleaned up the data, and those risks tend to be more. Nonetheless, companies sometimes use third-party vendors, and we have to look for where accountability lies when these things do occur. And that's where the lawyers come in. When you have a third party that is involved in deploying some type of AI solution to a company, the agreement, and I mentioned earlier in my presentation, software as a service agreement are not sufficient. The agreements between the company and the third party vendor must be such that the third party vendor must take the responsibility for some of those failures. And this is not so the company can dodge out of it, but because they are responsible and they're a technical service provider. So those agreements have to be very, very carefully crafted by lawyers when they're doing those, when you have third-party vendors providing a service.
Thank you. Thank you very much.
And Taya, I can quickly weigh in also on the question on the disclaimers.
Absolutely.
Because I think it's an important point for us lawyers. Now, disclaimers can help, but they won't fully protect you. Telling a user that AI can make mistakes, yes, it will set the expectations, it will show good faith, but as lawyers, our duties to our clients will override any small print. A court is not going to allow us to hide behind a disclaimer if we caused harm by something we should have caught. And we can think of it this way. if a junior associate gave you the wrong information and you passed it on to a client without checking it, well, you won't just say, well, I told the client the associate might make a mistake. And the same logic applies to AI. And what really protects us as lawyers is building habits around how we use AI. And that means we must always have a human review the output before it goes anywhere near a client. It means that we should have clear policies in our firms on what AI can be used and what it can't be used for, very important. And it means that we also keep records indicating that senior associates, partners were checking the work, because if something goes wrong, you want to show that you didn't just copy and paste. So a disclaimer is just a small piece of the puzzle. You have to factor in the human oversight processes and your judgment professionally. That's what's going to keep you and your clients safe.
Okay.
Is
All
it
right,
just
thank you.
Oh, okay. Can you hear me?
Yes, we can. Let's go ahead.
Okay. I was going to ask Nkem if you had any additions to this.
I mean, I think they've covered it quite aptly. So I think if there's any other questions, happy to jump on those.
So there is the one question which is still related to, our role as lawyers in relation to AI governance. And this person is asking what negative impacts of AI on legal practice are currently anticipated. Are there any negative impacts being anticipated, and what would those be, if
I
any?
mean, I think they're already happening, right? With junior lawyers being replaced, paralegals being replaced by AI. And I think this really, makes you question what is the future of a law firm going to look like, right? And how do business models need to shift when you think about client behavior changing, right? Every single client will put whatever you send them into AI and come back with questions they may or may not understand, right? We see the same in consulting, where our clients come back and they're like, well, my ChatGPT told me that I should ask this question, or this is wrong. And you then need to have additional time to actually engage them and explain to them and educate them and sometimes defend. But that also means that the client places less value on your work, right? Especially if it's a standard contract, an NDA, some kind of very basic SLA, right? They will tell you they don't want to pay as much, right? Because you're probably going to use AI to make it, which means that your billable hours are out of the window. So how do you make money, right? And we've seen new business models emerge like Harvey AI, where they've basically created AI that helps with the research, that helps with the actual, making the work faster for lawyers. But the question is, what is the value that you're going to create as a law firm or a legal practitioner that will keep you being relevant in the next 1 year, 2 years, 5 years, right? And I think that's something that we see across any kind of knowledge industry, any kind of professional services, any kind of service industry. The question really is, what is the value of human knowledge? What's the value of your experience? How do you position yourself? How do you change your business model? And we've seen very interesting, kind of new business models evolving. There's a security company, for example, Securitas. They have 200,000 security guards all over the world, and they have become an AI company. What have they done? They've taken all of the data that they have, from security guard reports to police reports to the security cameras that they have in stores, and they've used that to make predictions about how many guards they need in what location, to map guards and their locations to the stores so that they have shorter commutes, which gives them better work-life balance. It saves a lot of money for their clients as well. So H&M, for example, in the UK saved £30,000 on security guards because they need less guards. However, they're spending now on subscribing to that platform and having these AI-enabled dashboards that help them reduce pilfering in the stores, that help them understand what the security threats are in real time, right? And that traditional security company is now an AI company, right? And I think that's really the poster child for AI transformation, and that's what lawyers and law firms should start thinking about.
Thank you. I'd really like to get Bola's perspective on this because, you are involved in day-to-day legal practice. So how is this playing out for you?
No, thank you, Ken, for that, because you're so right. I just wanted to add a couple of things. And yes, it might seem super obvious, but I think it was Eton that says AI lies. Well, I would say that AI lies spectacularly and confidently. And for us, lawyers, a wrong case, missed clause, we know the harm that this can cause our clients, especially when no one is causing is checking the output. But I think the one that worries me is actually our client relationships. Law is built on trust as well as human judgment. And when we start to over-rely on AI, then we're looking at we are producing more generic advice when all our clients, what they actually want is something that is more tailored, something is more personal to them. So yes, our jobs aren't going to disappear as quickly as some people are envisaging it, but it is changing fast, and how we adapt is going to matter.
Thank you. Thank you. Thank you so much. There are a couple more questions, but I will take the last one. I think this is directed at Bola. So in practical terms, how can we get AI governance on the board's agenda? I believe each of the panelists has touched on this in some way. So the question goes on to say, is it management's responsibility or the company secretary or the chair of the board? So I believe this person wanted to be narrowed down just a bit. So I'll let you go first. Thank you. Yeah.
It's the board. The board has the statutory responsibilities, as simple as that. You cannot delegate it to anyone else. It's the board collectively. So we can't look for one officer in the company to have this responsibility. We have to own it as a full board, carrying out our statutory duties.
Thank you. Etan, do you agree? Nkem, do you agree?
Well, absolutely. I mean, it is the board, and we talked about all those regulations and so on, and the board will suffer harm if they don't step in and do this. We've been training board members and chairmen of companies for the last couple of years, and some of them are beginning to understand exactly where the risk to them lies. I just want to quickly touch on the issue of hallucinations, which you talked about earlier. One of the reasons for these hallucinations, Bola says it lies spectacularly, and that is absolutely true. It will say it in such a way, it's so logical, and it is sweet, well. But by the time you look into it, it can be horrible. I mean, we know the cases that all of you lawyers have heard about, lawyers being sanctioned by judges when they quoted laws which actually did not exist. But there is a hedge against that, and that has to do with how you write your prompts. So when you use an LLM and you write a prompt into it, you need to write the prompt in the proper way. And when that prompt, and this is what is called prompt engineering, but when you write that prompt, how you couch it and how you describe it, that often helps you to eliminate the hallucinations. And the interesting thing is that the LLM itself can help you write the prompt. So you can write in English just how you speak, or you can talk to it and say, hey, I want you to do this and this and this and this for me. I want you to look at the laws. I have this brief with this client. Be careful about that. Don't put so much of that in an LLM. But once you do that, you can ask it to write a prompt for you to get that information. And the chatbot structures the prompt in a way that reduces the chances of you actually getting a hallucination.
Thank you, Etan. And thank you so much to everyone for, your amazing questions and the panelists for your amazing answers. So if you have any other questions, please feel free to engage the panelists, reach out to us. You can share your questions with the members of the committee and we will send it over to the speakers. So we'll now come to the close of the session. I will hand over to Dr. Fati for closing. Thank you. Just checking, is she on the call? Maybe.
Okay. I think she's not on the call.
Okay.
No, she's not.
Okay. All right, great.
Yeah, she's not here.
All right. I see that Dr. Ogwemi is typing an answer to the last question that's left. But once again, thank you very much, everyone, for being here. This has been such a very robust session. So thank you once again. I just want to say on behalf of the Corporate Governance and Compliance Committee of the Nigerian Bar Association section on business law, of course, we've already heard our amazing SBL chair also speak as well as amazing guests. Just want to say a very big thank you to everyone. Let's keep the conversations going. This is an ongoing issue that I believe each and every one of us are currently experiencing or will experience in the course of delivering our duties as lawyers or as stakeholders as we begin to build our businesses or advise businesses. So once again, thank you very much for attending this very amazing session. And like what my first vice chair said, please feel free to engage with the speakers on LinkedIn. You can find them, just check their names, and I'm sure they'll be very helpful in sending the information across. Once again, thank you very much. And I do appreciate everyone for joining in. Thank you once again, and have a very, very, very beautiful rest of your day. Thank you very much.
Thank you. Thanks very much.
Thank you. Thank you. Thank you so much for joining. Thank you. Bye.
Thank you.